Hello everyone, today my friends and I will be presenting on how the Sexual Offences Against Children Act 2017 protects children from sexual offences. Before 2017, Malaysia's penal code governed most crimes, including sexual crimes against children. However, prior to Act 792, this statute was either unique or insufficient. Sexual Offences Against Children Act, hereinafter referred to as SOACA 2017, criminalized various sexual offences, including child pornography, sexual assault, exploitation, and grooming, and imposed severe punishment. The Act also highlighted the need to protect children from online predators and cyber exploitations. Special courts were created to handle cases involving child sexual offences, ensuring justice is administered promptly and compassionately. In the case of Hendra bin Mulana against public prosecutor, the court further explained that the major amendments to the Act consist of replacing child pornography with child sexual abuse material, but they have not changed the objective of the 2017 Act, which was to cater for certain sexual crimes perpetrated by sexual predators, including child grooming. Section 4 of the SOACA 2017 criminalizes the production of child sexual abuse material and sexual explicit conduct. This includes all forms of representation, including visual, audio, written, and combined images. The definition of sexually explicit conduct includes lewd activities, simulated or actual sexual encounters, masturbation, sadistic, masochistic sexual abuse, bestiality, and display of intimate spaces. Thus, this Act, as per Section 4, criminalizes any activities involving child sexual abuse material, as it targets the source of exploitation by making it illegal to generate, create, or oversee the production of such material. In addition, it seeks to safeguard potential victims by stifling the demands for abusive content through production prohibition. Even when an actual child is not directly involved, the law nonetheless applies to simulations and depictions that could exploit or put children in risk. Section 5 of SOACA 2017 criminalizes the creation, production, or direct production of child sexual abuse material, enhancing the legal framework to protect minors from sexual offences. Section 6 and 7 address preliminary acts and the exploitation of youngsters for such offences. Complementing it, Section 5 guarantees that everyone involved in the production of exploitative content is held accountable, including those of individuals who create, produce, or oversee such content. Section 6 criminalizes preparatory acts, providing proactive protection against offences under Section 5. Section 7 criminalizes using children for child sexual abuse material, addressing direct exploitation and safeguarding children against coercion and abuse. As per illustration, Section 5A, it demonstrates how the law applies to individuals involved in child sexual abuse material creation. For example, a director, A, creates such materials and enlists Z, an art director, to assist with the creative process. Z's participation under A's instruction constitutes an offence. This example shows that all contributors, regardless of their role or intention, are held accountable under the law. This section provides comprehensive accountability and shows every participant in the production chain is held accountable, preventing exploitation and discouraging future offences. It imposes severe consequences for those exploiting children or facilitating such exploitation. Section 8 and 9 of the SOACA 2017 provides robust measures to protect children from sexual offences by criminalizing activities related to the dissemination and sale of child sexual abuse material, including specific protection for children as recipients of such material. As per Section 8, it targets individuals involved in activities such as publishing, selling, distributing, promoting, or transmitting child sexual abuse material. It addresses the entire chain of activities, from production to dissemination, ensuring that no avenue of exploitation is left unchecked. Penalties include imprisonment up to 15 years, serving as a deterrent to those involved in child sexual abuse material-related businesses. Section 9 criminalizes the act of selling, renting, or making child sexual abuse material available to children, recognizing the unique vulnerability of child recipients. By penalizing all forms of dissemination and sale, these sections dismantle networks facilitating the circulation of child sexual abuse material. Section 10 of the SOACA 2017 protects children from sexual offences by criminalizing the possession or access of child pornography, with penalties of up to 5 years imprisonment, a fine of up to 10,000 ringgit, or both. This provision reduces demand for exploitative material by penalizing end users, thereby discouraging the creation or distribution of such content. It safeguards children by holding individuals accountable for indirect participation in their exploitation, reinforcing a zero-tolerance approach to child sexual abuse material.
The Sexual Offences Against Children Act 2017, SOACA, serves as a powerful safeguard to protect children from online grooming, a rising concern in today's digital age. Grooming occurs when an adult establishes a relationship of trust with a child to exploit them for sexual purposes. This exploitation can happen online through sharing inappropriate images or offline through harmful meetings. How the Sexual Offences Against Children Act 2017 protects against online grooming. Key protections under SOACA 2017. Section 11, criminalizing sexual communication with a child. Section 11 of the Sexual Offences Against Children Act 2017 prohibits adults from engaging in any form of sexual communication with the child. Such communication is deemed sexual if it involves sexual activity or if a reasonable person would interpret it as having a sexual nature. However, exceptions are made for communications conducted for legitimate educational, scientific, or medical purposes. Section 12. Criminalizing child grooming. Under Section 12 of the SOACA 2017, it is an offense for an adult to communicate with a child with the intent to facilitate a sexual offense, such as producing child pornography or enabling exploitation. Significantly, the law applies even if the intended offense is not carried out, allowing for early intervention to safeguard children from harm. Section 13. Criminalizing meetings after grooming. Section 13 of the Sexual Offences Against Children Act 2017 criminalizes an adult's act of traveling to meet a child after grooming them if the intent is to commit sexual offenses such as rape or exploitation. Offenders convicted under this provision face harsh penalties, including imprisonment for up to 10 years and whipping. Illustrations of protection under SOACA 2017. Preventing exploitation before physical meetings. An adult posing as a teenager builds a relationship with a child online and plans to exploit them through inappropriate photos or videos. Even without physical contact, SOACA 2017 holds the adult accountable for the harmful intent under Sections 11 and 12. Stopping facilitated exploitation. An adult communicates with a child to enable others to sexually abuse the child. SOACA makes such communication illegal, ensuring that the child is protected at the earliest stages. Why SOACA 2017 is critical? Children today face greater exposure to online threats due to increased internet use. The Internet Users Survey 2022 highlights that device ownership among children has risen by 20.1% between 2020 and 2022, increasing their vulnerability. 40% of school children lack knowledge about online safety. 83% of children take minimal protective actions, leaving them open to risks like grooming. SOACA addresses this vulnerability by proactively criminalizing actions that put children at risk and ensuring offenders face justice before they can harm. Parental awareness and online risks. As parents, you play a crucial role in safeguarding your children. Studies reveal that although parents are aware of the risks, they feel compelled to give their children internet access because it has become an integral part of life. However, this access comes with significant risks. A study found that 19.5% of children had been asked to discuss sexual topics online, and 61.5% were asked to meet someone they met online in person. A legal system designed to protect children. Recognizing the gravity of child exploitation, Malaysia introduced the Sexual Crime Court against Children in 2017. These specialized courts expedite cases involving SOACA-related offences, ensuring swift justice. By 2018, they had handled over 400 cases, making them an essential part of protecting young victims.
Good afternoon, everyone. My name is Tanuj, and I'll be explaining how the SOACA 2017 protects children against offences relating to sexual assault. Now, in order to understand how the SOACA 2017 protects children from sexual assault, we must first examine the various provisions that lie within Part 4 of the Act. Accordingly, the key provisions of Part 4 can be understood to be Sections 14, 15, 15A, and 15B. Section 14 of the SOACA 2017 regulates physical sexual assault against children and stipulates that it is illegal for anyone to touch a child's body for sex, force a child to touch any person's body, force a child to touch their own body, or to engage in any other act involving physical contact with a child that does not involve sexual intercourse. The explanations to this section illustrate that the sexual touching can be done with an object and even while the child is clothed, and that the court can consider a range of factors including the nature and context in which the act occurred. Now, this protects children against sexual touching by an adult and does not take into account the gender of the child or the offender, ensuring that this offense covers a variety of situations in which sexual assault can occur. The scope of Section 15 of the SOACA 2017 is considerably wide and covers situations that concern sexual purposes such as speaking or making any sounds, making a child exhibit any part of their body, following or watching a child, threatening to use any written, causing a child to consume visual or audio material of child sexual abuse material, engaging in or showcasing sexual activity in a child's presence, or making a child engage in activity that is sexual in nature. This wide scope is necessary to protect children from scenarios of non-physical sexual assault, which has been increasing as of late. To illustrate, in 2023, PDRM recorded more than double the number of non-physical sexual child assault cases than in 2018. Section 15 of the SOACA 2017 includes offering or causing a child to engage in, watching, participating, or benefiting from child sexual performances. This sexual performance can include any sexually explicit material performed before one or more viewers, even those recorded or transmitted by various means. Section 15B of the same Act protects children from 3 forms of sexual extortion: threats to engage in acts of a sexual nature, threatening a child to share or use any representation of a child's body engaged in sexual nature. This protects children against violent situations in which children can be extorted or threatened to perform acts of a sexual nature, and can protect children against situations in which they are both forced to perform acts of a sexual nature and extorted to do so, reflecting the grievous nature of the wrongs committed. In conclusion, knowing that there needs to be a venue more suited to the demands of child sexual abuse hearings, the Special Courts for Sexual Crimes Against Children were established pursuant to the SOACA 2017. The jurisdiction of this court encompasses all the forms of sexual abuse, but in particular includes physical and non-physical sexual assault, hence providing another venue for the protection of children against these crimes and resolution of such cases.
Part 5 of the Sexual Offences Against Children Act 2017 applies specifically to persons holding a position of trust in relation to children. It is aimed at protecting children from sexual exploitation by individuals who, due to their position, have access and influence over children. The law recognizes that those in these positions are in a unique and powerful position to take advantage of their relationship with the child, and hence the offence is considerably graver and warrants a heavier punishment. The Act treats any person in a relationship of trust with the child victim as provided under Section 16 sub 2 differently. Firstly, Section 16 of SOACA 2017 applies to a person in a relationship of trust. Additional punishments shall be added in addition to the punishment the offender is already liable for if he is found to be in a relationship of trust with the child. These additional punishments are imprisonment for a term of not exceeding 5 years and whipping of not less than 2 strokes. Section 16 sub 2 sets out that there exists a relationship of trust with a child if the child is under the offender's care, supervision, or authority. Examples of this relationship include full-blooded or half-blooded parent, guardian, or person, related through marriage or adoption, including de facto adoption, person who looks after any children for valuable consideration for any period of time, educators or wardens of a kindergarten school or a private or public institution of higher learning. It could also be a healthcare service provider in a government or private healthcare facility, a coach, and a public servant in the course of his duty under any written law in respect of the child. However, persons are not limited to the examples given. As aforementioned, the person only has to have the child under his care, supervision, or authority, making this section applicable to various circumstances. To sum up, the Act explicitly protects children from sexual offences committed by a person who has the care, supervision, or authority over the child victim and misused it to take advantage of the child that he is supposed to look after, instead of upholding the trust people have in him.
SOACA 2017 contains sections in Part 6 which describes the capacity of a child witness to provide evidence in a case and uncorroborated evidences given upon oath or otherwise. According to Section 17, a child is presumed to be competent to provide evidence regarding a case. However, this presumption is eliminated if the court finds that the child is not competent enough to provide evidence. Despite their young age, children have the ability to provide crucial information regarding a case. For instance, children between the ages of 6 and 12 years old have reached a developmental level that allows them to be competent witnesses as they are able to compare the information that they hear and see to information that they already know. Therefore, children can make truthful judgments regarding a certain subject matter. This proves that children are able to competently serve as witnesses in a case. However, some children lack the competence to act as a witness. Anxiety caused by face-to-face confrontation with the abuser, coupled with the adversarial nature of cross-examination, may interfere with a child's capability to testify against the accused. Thus, the competence of a child to act as a witness should be objectively determined by the courts. Overall, Section 17 ensures that a child's testimonies regarding a case can be sufficiently considered by the courts. Now, Section 18 states that a person may be convicted of a crime based on the uncorroborated evidence of a child given upon oath or otherwise. Now, before the introduction of this act, corroborated evidence was needed in cases where the court deems the child not competent enough to understand the nature of the oath. Now, the courts can convict a person based on the uncorroborated evidence of a child without the presence of an oath. Although Section 18 only applies to offences under this Act, Section 18 allows child abusers to be brought to justice without unnecessary cross-examinations. Now, Part 7 includes elements that, although not stated in earlier parts of this Act, are still needed to protect children from sexual offences. Specifically, Section 19 and Section 20 addresses key issues. Section 19 specifies that any person with information regarding an offence under this Act should report said information to the police. Failure to do so results in the person receiving a punishment or a fine. This section may influence relevant parties to aid in investigations by providing the police with crucial information regarding a case. Thus, this may accelerate the investigation and prosecution of a case. Section 20 ensures that an accused cannot use the excuse of not knowing that the child was under the legally protected age as a defense unless the accused exhausted all reasonable precautions to determine the age of a child. Thus, this section is crucial as it provides protection to children who look more mature compared to their age. While SOACA 2017 protects children from sexual offences against children remains a major problem in Malaysia. For instance, 6,540 cases spanning 6 categories of SOACA 2017 were reported between 2018 and November 2023. Now, due to these high statistics, parents should play an even more proactive part in protecting children from sexual offences. For instance, parents may protect their children from falling victims to sexual offences by strictly monitoring their internet usage. By doing so, parents can ensure that their children are not exposed to sexual or dangerous content online. Thus, preventive measures such as the one mentioned above should be carried out by all parties such as the government and parents to ensure the safety of all Malaysian children. Thank you.